The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
A mistrial avoided today in Texas, a massacre trial that's going on there. We're digging into why Adrian Gonzales was charged out of 100 other officers on site. And in Kentucky, deputies of a sheriff accused of killing a judge, they say their boss had become increasingly psychotic, why they're claiming they had no duty to warn. And new today, accused parent killer Nick Reiner's arraignment delayed again. What's happening behind the scenes for this celebrity's son? The court of law is done for the day, so let's get right to Court of Opinion. Welcome to Court of Opinion. I'm Julia Janae. Thank you for joining us for a space to air out opinions, challenge positions, and defend beliefs on the most impactful cases to our justice system. We've got a brilliant panel of co-counselors on deck. So whether it's the court's final opinion or the court of public opinion, we are digging into all of it right now. Let's get right to our top story this hour. A Texas judge denied a defense motion for a mistrial in the case against a former Uvalde school district officer. This is Adrian Gonzales, who's on trial. And this happened just one day after the trial began. Gonzales is accused of not doing more to save lives in the 2022 massacre that left 19 students and 2 teachers dead. Now, the trial ended yesterday with former Robb Elementary School teacher Stephanie Hale on the stand, testifying about seeing the gunman headed towards the school. But the defense abruptly stopped Hale's testimony when she shared information that the defense claims they had never heard before.
As we were all running into the classroom, I saw I don't know what to call him, horrible person, walking towards the door.
Can you describe him for us?
He had all black, long hair, and a gun.
This was such hard testimony to listen to, but beneath that, the defense said that they'd never heard that she saw the gunman in the area where their client would have been or could have been investigating. So that caused a halt to this case altogether yesterday. And the jury didn't even show up today so that the attorneys and the judge could unravel this alleged discovery violation by the prosecution. So in case you missed it, here are the highlights from those arguments today.
I will obviously at this point take any motions or arguments as far as remedies or proceedings in this matter. So, defense?
Yes, Your Honor. So, as the court will see from what's been tendered as far as our defensive strategy, this situation did have a significant effect on the strategy from voir dire all the way through. And through future witnesses, should they be called. We're in a position where we know under the law that we have to ask the court for a mistrial to preserve the record. However, if the court was not inclined to grant a mistrial, we do have other remedies we'd like to discuss.
We have given a continuance to the defense until tomorrow, and we're having a hearing outside the presence of the jury to entertain potential remedies and make findings of fact if necessary. But for the record, there was a motion for mistrial, and on that motion for mistrial, I'm going to find it's denied because I think the remedies available are sufficient to protect the due process rights of the defendant. And if y'all want to agree on a remedy, I'm happy to entertain that, but I have one in mind, and I'm going to give the defense some leeway on how they want to proceed with the witness in front of the jury in the event she's recalled after we talk. So once again, we're outside the presence of the jury, and I've given counsel an opportunity to confer on potential remedies in regard to the witness. So what do y'all have to report?
Judge, we've had pretty productive talks, and I believe, and correct me if I'm wrong on any of this, that the proposition at this point, with them still reserving the right to think of it overnight and start in the morning, is that they continue their cross-examination they get to also play the entire statement that she made. We would then get to redirect, and then they still reserve the right to ask you to exclude all the testimony. And
Yeah.
that part we feel.
Yes, Judge, and under the idea that we want to unring the bell first before there's an instruction to exclude it, because and have them exclude it all in its entirety, which is fine. But we would like to be able to unring that bell and then make that decision. Depending on how that cross-examination goes, we might not ask to exclude her, because there are some things that she says that we're just trying to evaluate her testimony after it is to see, on balance, is it more beneficial to our case, or is it not? Like, you know, after we've unrang the bell. But if we determine on balance that it's less beneficial, we would still like to have the Heath remedy for the late disclosure.
Well, for the record, I'm offering it right now. I'm offering the Heath remedy to exclude her testimony immediately. But if y'all want an opportunity to try this, if both sides agree, I'm happy to implement that agreement.
Yes, Your Honor. What we believe is ultimately we believe we're asking the court to exclude. The only issue is that we just want to be able to unring the bell first.
We'll let the defense proceed as we just discussed, and she needs to be here at 9 o'clock in the morning, and then I'll make a decision on exclusion with everybody's participation after we rest and or actually she's finished with redirect and recross, whatever the case may be.
Yes, Your Honor.
So there you have it, the teacher's testimony to be excluded, and all of this is going to be preserved for appeal in the future if the defense has to go that route. So let's get right to our guest panel, everyone who is standing by to talk about this huge case in Texas. Joining me in studio tonight, we have criminal defense attorney and former prosecutor Marie Pereira, and joining us remotely, we have Chief Public Defender for Oakland County, Michigan, Paulette Lofton, and former federal prosecutor and president of the West Coast Trial Lawyers, Nima Rahmani. A power panel here on Court of Opinion. And let's get right to it. Marie, let's first start with this near miss when it comes to a mistrial. What's your opinion on the judge's ruling on this discovery issue?
I agree with the judge, and I don't think that the discovery violation was up to par to creating a mistrial situation over that. I mean, Stephanie Hale, she was a very convincing witness, very sympathetic, but her testimony really did not create a situation where the judge would say that there was no other remedy other than a mistrial. All she said is, I saw a guy with long black hair, the monster. And apparently she didn't say that when they interviewed her and got a statement from her prior. So it was an inconsistent statement. That's why you have cross-examination. You cross-examine the person, bring out the inconsistency, and then you let the jurors figure it out. They could believe all of her testimony, some of it, or none of it.
Paulette Lofton, let me get your opinion on everything that happened today and where we go from here in this trial with the jury having already heard this teacher testify.
Well, first of all, there is no such thing as unringing a bell. I think when you tell a jury to not listen to something, they're going to focus more on what they were just told not to listen to. So that's a fallacy. But I agree. I don't think it should have been a mistrial. That's the exact reason that there is cross-examination. You never know exactly what a witness is going to say. Yes, they may say something one way at a preliminary exam or a prior hearing or in an interview. But now that they had time to think, they're going to say things differently. And that's why you have to really attack witnesses on cross-examination.
Nima, what's your opinion on whether this could be something that would be successful on appeal if there is a conviction?
I don't think it's a basis for appeal, and I agree with my defense attorney counterparts. Look, I could tell you I'm as pro-prosecution as they come, and I think this is a potential unforced error and unnecessary appellate issue by the prosecution, but it's not going to be in a mistrial. This case all comes down to what did the defendant know, and when you have a teacher who's testifying, at least that she told law enforcement earlier that the shooter was near the defendant, that is a potential problem. That's potential Brady material. That's something that you have to disclose if you're the prosecution. You can't be doing these types of things and creating discovery problems, constitutional violations. I agree. I don't think it was intentional. I don't think the state was trying to do anything here, but you have to disclose this type of evidence, because now, even if you get a conviction in an already difficult case, now you have to deal with this issue on appeal.
You have to for a fair trial. Thank you all for weighing in on that. I want to turn our attention to something in this trial that I've seen as a theme from our Court TV, Legal Eagles Online, our viewers weighing in, the Court of Public Opinion. They've all been questioning why Adrian Gonzales, really wanting to know why out of the 370 or so law enforcement personnel that arrived at that school, why is he the one that's on trial? So we're going to dig into that, make it more clear. Here's a look back, an important part of the prosecution's opening statement detailing why.
Melody Forrest was also out there that day. She heard the shots fired. She had a concern for the kids. That when that happens and the last kid enters, she's face to face with a gunman. And he fires on her and she turns to run. And when she turns to run, she trips and she falls. And when she gets up, Adrian Gonzales, the police officer, is there. And she says, he's over there. She urges him to go get him. He gets on the radio and says, shots are fired, he's wearing black, he's in the parking lot. He knows where he is. But Adrian Gonzales remains at the south side of the school.
Marie Pereira, let's talk about it. What's your opinion on this? Because this prosecutor is saying he's the one who had the opportunity before the gunman got inside and barricaded himself in those classrooms. He could have run after him in that moment.
You know what? He's trained to do what he thinks is necessary at the time. So we can't say because he didn't go inside at that moment that he's responsible for negligent treatment of those kids and not looking after them, right? He used the information he had based on his own judgment. So to hold him accountable and say you're the scapegoat for everything that happened, even though there were 400 officers at the end of this whole tragedy, and they singled him out, it seems like the shooter was killed, those children are dead, other adults are dead, and somebody has to pay. And I think that's what's happening here. Same thing that happened with Nicholas Cruz. And in that case, the officer was acquitted.
Officer Scott Peterson, yeah, he was acquitted, accused of very similar charges. I want to bring Paulette in because you have a unique perspective on this one. You have represented a school shooter in the Oakland school shooting there in Michigan. What's your opinion on this case and the charges against this defendant?
I think it's going to be difficult to prove that this officer is to blame for all of the tragedy. I know that he was one of the first officers on the scene, and it seems as though decisions that he made early on kind of steered what happened here. So I know that the prosecutor is definitely going to argue that. But like Marie just said, is it his fault for every single other thing that happened that day? I think that's a stretch. But I think the facts are absolutely so horrible. The courtroom, I'm sure, is full of grieving parents. And I think the jury is going to have a hard time following the law. I just think it's going to be really hard for them to return a verdict of not guilty in a town that has just suffered so much tragedy.
Yeah, and they even moved this 80 miles away to try and get a fair and impartial jury. But we were all impacted by this, Nima. I mean, we all remember this story when it happened in this tragedy. And I want to read something from the indictment against Gonzales. They say he failed to engage, distract, or delay the shooter in that moment that I just mentioned as part of his active trainer shooting that he should have known about active shooters and his training. So with that, do you think the jury is going to pay attention to just that part and just that moment that may have been a tragic missed opportunity?
Well, that's what the prosecution is going to have to do. Now, normally there's not criminal liability for a failure to act, but police officers do have that duty. And what the state is saying is, had Gonzales done his job and engaged this suitor, some of those children may have been alive. But Marie talked about it. It was a similar case, Parkland school shooter, and they argued, being a coward, does that make you criminally liable? I think the defense has even taken this one step further and saying Gonzales was not only not a coward, he was acting responsibly. He called 911, he waited for backup, he was helping the children that were able to escape. And I think the toughest fact that the prosecution has is the other law enforcement that arrived, they didn't engage immediately. So I think that's the biggest challenge, and I think the question that the state is going to have to answer, and really, frankly, the best evidence that the defense has here.
Tomorrow, those jurors are coming back into this courtroom, and they're going to hear testimony from more people, more witnesses. For the prosecution, we'll, of course, be covering that right here on Court TV. We do have to get to a break. Our power panel is coming with us. Coming up, we're going to turn our attention to Utah. There's a grief author who's been accused of killing her husband, and she's been back in court for a multi-day evidentiary hearing. We're going to be breaking down that evidence is in danger of being kept in or out of her upcoming trial.
The Court TV podcast will return.
She met up with acquaintance 2 at a Maverick gas station in Draper and purchased from him 15 to 30 round green-blue pills, which she understood to be fentanyl.
1 or 2 pills might be accidental. 20 or 5 times the lethal dose is not accidental, Your Honor. That is someone who wants Eric dead.
A Utah mom accused of killing her husband with a cocktail laced with fentanyl. She was back in court today for an evidentiary hearing. This is ahead of her trial that's happening within the next month. Curry Richens is charged with killing her husband, Eric, and this happened in March of 2022. After his death, she was not immediately arrested. She wrote a children's book about grief and promoted it on TV. Now, the case took a major turn in October when there was a key witness who was a drug dealer who changed his story. Robert Crozier now says that he sold OxyContin to Richens' friend, not fentanyl as was previously claimed. Now, the defense attorney says this could be a game changer for the trial. Jury selection begins on February 10th, with the trial starting on February 23rd. And today, key evidence was hammered out in an evidentiary hearing. What evidence was in danger of being kept in or out? We are breaking it down now. First up, the testimony of a state witness hopeful, Molly Amon. She is an expert witness specializing in behavioral threat assessments. Now, the state said she may become helpful at trial in explaining Corey Richens' alleged violence. Let's listen to what the prosecution argued about how her testimony would be used at trial and then how the judge ruled on it.
Molly Amon will not be saying, Miss Richens fits this profile, therefore she committed murder.
Right.
That's not the testimony. That's not what we would elicit. We agree that would be improper, and that's not our intention with Ms. Amon's testimony. It's more to assist the jury in a framework to understand how targeted violence occurs.
In the event that the defense makes an assertion in its defense case that is categorical and general, for example, something to the effect of that it's simply not credible that a person would engage in a weeks-long campaign to kill another person in the absence of an imminent threat to their safety. Then Ms. Amon's testimony regarding the retrospective study of completed killings, showing a feature such as a preparation and plan over time, would be helpful to the trier of fact under Rule 702A to rebut that generalized categorical assertion by the defense.
So the long and short is the defense said this is junk science, shouldn't come in. The judge says it can come in, but only if the defendant puts on a theory of the case that says that there was no kind of crime or couldn't be a crime like this, and then this witness could testify in a rebuttal case. So let's bring in our guest panel to talk about this part of the evidence. We have attorneys Marie Pereira, Paulette Lofton, and Nima Rahmani with us. Nima, I'm going to start with you on this one. What is your opinion not only of this evidence with this former FBI behavioral procedural analyst, but also where we go from here in the Corey Richins trial.
Julia, right ruling by the judge, and this is why. If you're going to put on a defense that it wasn't me, I didn't buy the fentanyl, I thought it was something else, that is a very different type of defense. You can't bring an expert like this to dirty up your victim. Now, if you're going to present the defense that it was me, but I was justified because I was physically abused, I was the victim of domestic violence, I was acting in self-defense, then maybe you can present a expert witness like this for the limited purpose of talking about the abuse and the effect that it has on the victim of domestic violence. But you can't bring a domestic violence expert when your case and your defense has nothing to do with domestic violence, at least what's been argued so far by the defense attorney.
Paulette, what do you think about the state even wanting to bring in a witness like this? What does that necessarily say about their case if they think they have to explain to the jury how a wife could snap and kill her husband?
I think it makes them look like their argument is going to be weak. I don't think you need that. I think that's something that the jury could come to understand by argument and questions of other witnesses. I don't think that they need this type of expert. But I agree with the judge. I think if the defense opens the door in certain ways, then this witness maybe, should be able to come in and testify. But again, I think it really shows that the prosecutor is grasping at a few straws and maybe doesn't have as strong of a case as they would have hoped.
Marie, your opinion on this grief author who is now on trial, heading to trial in February, and we're hammering all of this out now.
But it's the prosecution that's trying to bring this witness in, right? It tells me, like what Paulette just said, it makes their case look weak if they have to bring in an expert to explain why the defendant would be prone to murder. It almost sounds like a backdoor propensity argument against the defendant by bringing someone to explain how does a person get so much hate in them that they would want to plot to poison their husband. What is the profile of that defendant and how she got there? They should never be allowed to do that. So unless a door was open,
which hasn't happened yet,
they shouldn't be allowed to do it. And it really makes their case from coming out the gate look kind of weak.
We will
that
see
they needed to even go there.
We'll see what happens at trial, and if that is something that the defense brings up, like if they try to say self-defense. Really quick before we have to get to break, let's look at another piece of evidence that was dealt with today. So Corey Richins is also facing forgery charges for signing her husband's name allegedly to a power of attorney that allowed her to gain access to different things financially. And this state expert witness, Matt Throckmorton, he is someone who is a handwriting expert who could determine if the victim, in this case, Eric Richins, signed documents. And again, she is facing those 3 counts of forgery. So this qualified expert in determining if he signed the documents or if the defendant forged his signature, the court found that his methods are reliable and that it does not ignore uncontroverted facts. So the handwriting analyst is coming in. Nima, is that unusual for a handwriting expert to be allowed in?
Julia, not at all. This is exactly the type of expert that should testify. Obviously, if one of the charges is forgery and the allegations are that she signed her husband's name, especially when there's a financial motive here, including life insurance, handwriting experts testify in every courtroom in this country every single day.
All right. Thank you all for your opinions. We're going to leave it there. That trial, again, happening next month. We will follow it all here on Court TV. Up next, when we come back, we're going beyond the gavel, breaking down the biggest true crime cases. And this one has been nicknamed the Utah Adelson's case. A mother is set to stand trial for the slaying of her son-in-law. Her own son also charged in his murder, and her daughter serving prison time after pleading guilty to conspiring to kill her husband. We're talking about it after this.
Now, back to the Court TV podcast.
Welcome back to Court of Opinion. Let's go beyond the gavel. Those cases that have not played out yet inside of a courtroom with a trial, but while the investigation and process is playing out, we are paying attention. And our focus today is a case in Utah, the family murder plot case where the defendant, Tracy Grist, was back in court for a status conference. Grist is charged in the murder of her son-in-law, Matthew Ristelli. He was shot and killed by Grist's son, Kevin Ellis, when he went to pick up his wife, Catherine Ristelli, and their children at Grist's home. Now, Catherine admitted to conspiring with her mother and her brother to lure her husband to Utah under false pretenses. All of this, they're accused of trying to kill him to get help with that, and she used her family to get help with that. Let's break down this case and first hear the background on it from Court TV anchor Ted Rowlands.
At this point, the least I can do is speak the truth on what happened to give Matt and his family the justice they deserve.
That was Catherine Ristelli pleading guilty in July of 2025 to second-degree murder and conspiracy to commit murder in the death of her husband and father of her children, Matthew Ristelli.
The state alleges that Kevin Ellis, Tracy Grist, and Catherine Ristelli conspired to murder Matt, who was Catherine's husband.
It's rare that we have a murder, let alone one where someone's lured from another state to our city to be murdered.
Prosecutors say a few weeks before the July 12, 2024 shooting, Catherine left her husband in California and moved to Utah with their children to live with her mother, Tracy Grist. During that stay, Catherine allegedly conspired with her mother and her brother, Kevin Ellis, to kill her husband.
Catherine and Tracy worked together to lure Matt into driving to Utah and to entering Tracy's home where Kevin was waiting armed with a handgun. Almost immediately after Matthew arrived, Kevin shot and killed him.
Catherine allegedly created a ruse of reconciliation with her husband while Matthew drove to pick up Catherine and their kids, thinking they would all go back to California. Prosecutors say he was being tracked by an Apple AirTag. Catherine's mother, Tracy Grist, is accused of making changes to the home by removing the screen door so that Matthew would have easy access to the home. The alleged murder plot included a self-defense claim accusing Matthew of walking in to the home unannounced.
Matthew was unarmed. A knife was then planted in Matthew's hand to try and cover up the conspiracy and claim the shooting was in self-defense. The knife was held in the wrong hand. See, the knife was found in Matthew's right hand, but Matthew Ristelli was left-handed.
Tracy Grist and Kevin Ellis are each charged with first-degree murder. Both have pled not guilty. Catherine has been sentenced to 1 to 15 years in prison.
Now, Matthews' mother, Diane, says the family isn't telling the truth. In a recorded call that was played in court during a hearing, Diane confronted the other mother-in-law, Tracy Grist, about the shooting.
In my mind, my son was only being protective and loving and kind to the people in my home.
I think the family has a lot of explaining to do. This whole thing seems like a setup.
We would never plan to hurt someone.
That was, of course, before all of the arrests came down in this case. But get this, we have been calling this the Utah Adelson's case, not because we have dubbed it that, but it's close enough because the prosecutors in this case say that Tracy Grist searched for Adelson names before this happened, including Catherine McBanawa, Donna Adelson, and other things relating to that Florida case for the death of law professor Dan Markell. So research, they say, had to do with them trying to figure out what they should do with their situation. Now, Kevin Ellis, the one who pulled the trigger, his trial is actually slated to begin next week on January 15th with jury selection. Let's get to our guest panel. We have with us Marie Pereira, Paulette Lofton, and Nima Rahmani. Marie, take us to your opinion on this case. There's so many layers to it, but Tracy Grist was in court today. Her son is about to stand trial. He's the first one to go.
I think they were searching up the Adelsons in order to figure out what not to do. Because nobody who wants to execute a murder like that, where you're sending hitmen or, setting someone up because of the fact that they want to keep your grandson in a state, they didn't succeed. So why would they look to the Adelsons as a roadmap to successful murder without getting detected? They're idiots. They actually put the gun in the wrong hand. So they tried to make it seem like Maybe he did something to himself, or it was self-defense, or whatever. They didn't figure it out.
Nima, the allegation is they used an AirTag to track him. This was a father basically coming for a custody-type drop-off and swap, unaware of what was happening, according to the prosecution. Now, the defense says he broke into the home.
Well, Julia, they're arguing self-defense. It's going to be very tough in this case. Marie talked about some of the facts, and really similar to the Adelson case. I mean, you couldn't have really scripted it differently. Now, maybe they had plotted and planned this before Donna was convicted, Wendy. Some of the individuals involved, obviously, were brought into this later. Obviously, Wendy was never prosecuted, but that case was certainly a very slow burn, and the Adelsons themselves didn't face justice until some time later. But I agree with the severance motion. When you have inconsistent theories like this, obviously you have Kevin, who may allegedly pulled the trigger. His defense is going to be very different from Tracy, the mother, who may be arguing self-defense. Obviously, she's very differently situated as a woman and being older. So severance motion, properly granted. We're going to have separate trials in this case, just like we had in the Dan Markel Adelson case.
Paulette, a very different thing with this trial, though, is that you have what would be the Wendy Adelson of this family cooperating with police. We did not have that in the Adelson case. Are you expecting we may hear something about a plea before this trial going forward?
I would think so, especially if she's done her research on the Adelson case. You definitely want to take a plea and not take your chances in front of the jury like Ms. Adelson. So I do think that there will be some flipping and hopefully some movement in a plea. I agree. I think severance of this case or these different trials is appropriate, because I think that if they do all go to trial, the defenses are going to be so inconsistent that there's no way a jury would be able to try to determine what attorney is arguing what defense for what defendant. So I also agree that the judge made the right call on that.
All right, Marie, them not going to trial altogether, what are the benefits and what are the problems with that?
There are more benefits that I could think of, because you don't want to be close to the person they're saying who did it. You want to distance yourself, not just physically, the optics, but you just don't want to, because like Nima said, the differences are going to be in the defenses. They're all going to be pointing the finger at each other. So you can't have all of it together. That would be disastrous. And I think any attorney on the defense side would want to keep them away from each other, because the competing defenses are going to ultimately be pointing the finger of culpability at each other.
Yeah, Nima, weigh in on that, because they are separate and it seems to have worked, with the wife already taking the plea deal, already serving her time and coming in. But how are they going to distance this? What if Kevin Ellis claims that he didn't know what was happening, they were planning it, and he just thought it was an intruder?
Yeah, so Marie talked about it. You see a lot of finger pointing in these multi-defendant cases, especially when there's one trigger man. Now, obviously, look, if you're the prosecution, you want to try everyone at once. That's good for judicial economy. You can dirty up all the defendants. It's going to be hard for the jurors to parse it out. But obviously, that's not fair. That's not what our Constitution or our Sixth Amendment requires. So these motions are routinely granted. Now, look, it's generally harder to prosecute women in these types of murder cases, especially elderly women. So I certainly would like to be either the cooperator, the ex-wife, or the mother-in-law. The son is going to be a little bit more challenging, especially if he's the one the ballistics, gunshot residue, and cooperating witnesses point the finger at. But if you're the prosecution, what's very important is you don't want to rely on cooperator testimony alone. Some of the jurors think they're snitches or rats, and they're just lying to save themselves and get a reduced sentence. And they usually are getting a reduced sentence. So hopefully you have some forensic and other evidence that backs up your theory of the case.
Yeah, Paulette, Nima makes a good point about optics here, with the mother-in-law being someone who may not be looked at as being as involved as perhaps the other actors. We don't have the trigger man on trial yet. We have a daughter who took a plea. In the Adelson case, it took some time before they even thought they had enough to go after the mother-in-law.
That is correct. I mean, I definitely think the case is weaker for her. Obviously, if we get the ballistics back and it does show that Kevin is the one that did the shooting, and this gentleman was shot over 5 times, I think the case is pretty solid against him. But what evidence then will be used against the mother-in-law, right? I don't think there's definitely as much. I think age, as was just mentioned, does play a part in a jury's decision. Obviously, it didn't help Ms. Adelson, but I think here it may be a little bit different. She appears to me to come across a little bit different than Ms. Adelson did.
But I think at the end of the day, when you're talking about a theory of conspiracy, right, it doesn't matter if you're an old, pitiful-looking old lady, because you could still plot to murder, old and all. So if it's based on a theory of conspiracy to lure him and with premeditation, get him in that house, say he came in, fake some self-defense situation, you know, it's bringing me back to Lori Daybell, when they lured the husband in the house and then her brother shot him and then she went to Burger King, remember that? Everybody went down. It doesn't matter age or nothing. They're going down. All of them should go down.
Great comparison with that case. Everyone stand by. We do have to get to a break. When we come back, we're going to get some hot takes and cold facts. Our panel is going to give us their takes on today's biggest cases, and we're going to get into some of these big headlines today. One of those being Nick Reiner's high-profile attorney calling it quits, an update on the case of a sheriff who shot a judge in his chambers, and a rapper heading to prison is excited to hang out with a fellow high-profile inmate. We'll talk about it.
This is the Court TV Podcast.
On these facts, we have Marie Pereira, Paulette Lofton, and Nima Rahmani with us. Marie, I'm going to start with you. 25 seconds is what we give you so that we can get to everyone and get to all of our stories. What's your take on what is happening behind the scenes there?
I think it's all about the Benjamins, baby. He don't work for free. You cannot get an attorney like him to represent you without getting paid. And you also can't use the money from the people you allegedly murdered to pay for your defense attorney. So somewhere down the line, somebody shut it down. Maybe his siblings said, you're not going to use your trust fund money that came from our dad and mom to pay for you murdering them.
All right, Paulette Lofton, your opinion on this latest development when it comes to Nick Reiner.
I agree. He came on very, very early into the arrest. And I had questions at that time. Who's paying for this? So I think either feelings changed after the investigation showed what it showed, and now people aren't willing to pay the money that is needed for this very, very good attorney. But also, if it's a case where it's going to be a battle of the experts, the Public Defender's Office has the funds to pay amazing experts, and that is definitely the way to go.
Good point. Nima Rahmani, he took the Karen Reed case for free. That's what was purported. But there was a large GoFundMe and different things for her legal defense. What do you think about this?
Julia, I'm sitting here in downtown LA and my phone was blowing up this morning about a mile away from the courthouse. Like, I agree with Paulette and Marie. This is Mr. Green not showing up. Alan Jackson isn't cheap. He's probably going to want a 7-figure retainer for a double murder special circumstances case between the associate attorneys, experts, and everything. Also agree with Paulette. I'm sure the PD's office will do a great job in this case, but I don't think the siblings are paying for this type of representation.
All right, that arraignment has been moved now to February 23rd. Let's get to our second story. This one out of Kentucky. A motion to dismiss hearing took place today in the civil lawsuit against a former sheriff, Sean Steins, and 3 of his employees. Now, Steins, of course, is accused with the fatal shooting of District Judge Kevin Mullins, caught on camera. And during Tuesday's hearing, attorneys confirmed that there was an agreement to dismiss the official capacity and negligence claims against Steins, leaving only individual and intentional claims in the lawsuit filed by the Mullins family. Now, the partial dismissal focuses on Steins' personal liability rather than his role as an elected official. And there are employees who are also named in this case. They said that they noticed some things about Steins leading up to this, that he was psychotic, but they say they didn't have a duty to warn anyone. Marie, they want to be out of this lawsuit. What's your take on this one?
I think they should be out of it. How'd they get involved in this? Like, because he was acting kind of kooky, I had a duty to report, and because he ended up having lunch with the man, going back and then murdering him, that's my fault? Why does it have to be their fault? I'm glad they got out of it, because they should have never been brought into it in the first place. That's crazy.
All right, Nima Rahmani, your thoughts on this one?
Look, this is a civil lawsuit. It's all about money, and you want to get to the deep pocket. This is what happens in every one of these wrongful death cases where there is an officer involved shooting. I can guarantee you we're going to have one related to the Minneapolis shooting today. So you try to get them on course and scope. You try to get them from negligent hiring, retention, supervision. Do everything you can to cast as wide of a net as possible so you can get the government or someone with the ability to pay these types of civil judgments.
And Paulette, these employees reportedly say that he was acting very strange. Their boss, is that going to be coming into this criminal trial when it goes forward?
Oh, I'm absolutely sure it will be. But I agree with Marie. I don't think they're liable here. What duty do you have to report if your boss is acting slightly erratic? I mean, obviously the judge felt comfortable enough to go to lunch with him that day. If he was acting that erratic, you would think that he would have chosen to skip lunch. So I don't think they may be chasing some deep pockets, but I don't think the liability should be with the other officers.
All right, we will continue to monitor that case. Let's turn to story number 3. Rapper Tekashi 6ix9ine is going to be spending 3 months at the same jail, currently housing Nicolas Maduro, the Venezuelan president who is facing federal charges. And this rapper, he is there because he was someone who turned prosecution witness, but he has violated the terms of his release, and he pleaded guilty to possessing cocaine and MDMA in March 2025, violations of that supervised release stemming from those racketeering charges. Now, this jail is notorious for its high-profile inmates. Currently, Luigi Mangione is there as well, but Tekashi says, according to TMZ, that if he bumps into Luigi or Maduro, he wants to dance with them, and he's getting a lot of love on social media. Let's take Paulette for this one first. Just your reaction to him being there, and it also being a place that houses someone who is attention is on him internationally.
Obviously, I just think he wants attention. So anything he can say on social media to get some extra clicks, he's going to say it. But can you even imagine the security risks at that facility with that many high-profile detainees? I do not envy anyone that works at that prison system.
Nima Rahmani, former federal prosecutor, any chance they will even cross paths in this case?
No way. The only way they're going to cross paths is Tekashi 6ix9ine did some of that Venezuelan cocaine. Maduro is going to be isolated from the general population. That's going to be the biggest trial, certainly one of the biggest drug trials in American history, maybe the biggest trial in American history. So the last thing MDC officials are going to want is the former head of state of Venezuela to be anywhere near the biggest snitch that we can recall.
Marie Pereira, let's get your take. You're from there in New York. That's where you were a former prosecutor, the Brooklyn MDC. Your take, 25 seconds.
It would never happen because they wouldn't mix those two people together. And if it did happen, there's classism amongst criminals too. And I don't think the former leader of Venezuela would want to be chilling with Mr. 6ix9ine with all those tattoos on his face. It would never go down like that because even criminals like that care about who they're associated with, and he will not be friends with the former leader of Venezuela. Not going to happen.
And that's where we have to leave it. Thank you to our power panel for all of your opinions this hour. Paulette Lofton, Nima Rahmani, and Marie Pereira here in studio. Thank you all for connecting with us this hour on Court of Opinion. I'm Julia Janae, reminding you that while we all have opinions, they should be rooted in facts, and we should be striving to respect the other's opinion even when we don't agree.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.